Howdy. We're going to conclude our discussion of Module 13 with a discussion of judicial review in a democratic system. Just to define, judicial review just refers to the power of a court to declare the acts or actions of other public officials unconstitutional and therefore null and void. We might note that since this judicial review is exercised by non-elected judges who serve for terms of good behavior, it is a power that is inconsistent with the democratic principles of majority rule and popular sovereignty. So this is an extraordinary power that non-elected judges can nullify laws presumably favored by the majority. And as judicial power goes, it's unusual, at least until recently. Very few other democracies grant such power to the courts. Now, you might suppose that something as unusual and as extraordinary as the power of judicial review is, that it would be spelled out with great care and detail in the Constitution. It's not. Nowhere does the Constitution explicitly say that judges have the power to declare laws passed by Congress unconstitutional. So how is it that U.S. courts got this extraordinary power? And the answer is the Supreme Court just claimed it. Judicial review officially originated in the case of Marbury versus Madison in 1803. Now, let me give you a little bit of background, a little bit of context here. The Federalists had been in power since the beginning of the Republic. In the election of 1800, Thomas Jefferson, the founder of the Jeffersonian Democratic Republican Party, won the election. And it was a bitter election. The disagreement and disputes between President Adams, the Federalist president, and Thomas Jefferson's were intense, and the campaign was especially nasty and intense. And the Federalists viewed Jefferson's election as a tremendous threat to the new republic. So after the election was over, and the Federalists had lost the presidency and also lost control of both houses of Congress, during this lame duck period, lame duck period is the period after the election but before the new officers, new president, or new members of Congress take office. In 1801, this was an unusually long period because the new president was not inaugurated until March, and so there were 3 months or more for the Federalists remaining in power to do some damage. And what they did is that the Federalist Congress enacted the Judiciary Act of 1801, sometimes it's referred to as the Midnight Judges Bill. And so this new law was passed, creating hundreds of new judges, and also modifying the power of federal courts. And President Adams got busy filling all of these new judgeships, and the Federalist-controlled Senate was quickly confirmed those nominees. And all that was left was to deliver the commissions to these new judges, and a commission was just a formality, a formal recognition indicating that they have been duly appointed and confirmed and are now commissioned to exercise federal judges. At this time, it was the duty of the Secretary of State to deliver these commissions, and that Secretary of State under Adams was John Marshall. And so he was busy up until the very last minute, the very last night, delivering these commissions. And one of these commissions was to himself, because he had been appointed by President Adams to be Chief Justice of the Supreme Court. But time ran out, And there were a handful of lower level judgeships, federal judgeships, remaining to have the commissions delivered. And so he left them on top of his desk, assuming that the new Secretary of State, which was James Madison, would deliver those commissions. Well, as you might imagine, Thomas Jefferson and the Jeffersonian Republicans were not happy about this. And so Jefferson ordered his Secretary of State, James Madison, not to deliver any more of these commissions. One of those commissions that wasn't delivered was to a man named William Marbury, who had been appointed to a judgeship as Justice of the Peace in the District of Columbia. Now, this is not a great judgeship, but it was a federal judgeship, and it was something that he wanted. And so he went to court, and he went directly to the Supreme Court and asked the Supreme Court to issue a writ of mandamus to James Madison, ordering him to do this. And a writ of mandamus is just a court order that orders a public official, a government official, to fulfill their official duties. And it was Madison's official duty to deliver these commissions. There was no politics involved. The problem is that this whole circumstances, all of these circumstances, put Chief Justice Marshall in a political bind. On the one hand, if he ruled in favor of Marbury, which he surely wanted to do, and remember, it was his fault that he never got around to delivering Mr. Marbury's commission to him, and so he wanted to rule in favor of Marbury because he wanted that Federalist to be in power. But he knew, Chief Justice Marshall knew that if he ruled in favor of Marbury, that Jefferson would just ignore it. And from the Federalist point of view, that would be the worst of all worlds, because if the Supreme Court issued a court order and Jefferson ignored it, that would show that the Supreme Court had no real power. And also remember that the new Democratic Republican majority that was in power were thinking about impeaching John Marshall. And so Chief Justice Marshall thought that if he ruled the way he wanted to, that it would probably get him impeached. So Chief Justice Marshall engaged in a little bit of political finesse that must rank up there with some of the most audacious political moves in history, but a political finesse that got him out of this bind of his own making. And how did he do that? He got the Federalist in power on the Supreme Court to declare part of that law unconstitutional. And the part of the law that was declared that the court declared unconstitutional was the part that granted the Supreme Court the power to issue writs of mandamus under their original jurisdiction, and that's why Marbury went directly to the Supreme Court to ask for this writ. So declaring that part of this Judiciary Act unconstitutional was a huge power grab that achieved the Federalist goal of making the Supreme Court a co-equal branch of government, and in general expanding the power of the federal government. And the finesse here was that Jefferson, who was no doubt livid about this, required Jefferson to do what he was going to do anyway, and that was not deliver Marbury's commission. And then, in a moment of foresight, the Supreme Court then did not declare another federal law unconstitutional for over 50 years. And that was in the case of Dred Scott versus Sanford, which was a major factor that led to the outbreak of the Civil War. And so that's a thumbnail of the history and the political finesse and how the courts came to have judicial review. When we observe how often the court strikes laws down, what we discover is that it's not a power. It's an extraordinary power, but it's not a power that the Supreme Court has used very often. And so here's just a count of all of the federal laws and state laws that have been declared unconstitutional since 1803. And notice that there was one in 1803 in the 1800s, and then there was another one again until 1857, and just a handful in each decade since then. So if you total up all of these federal laws that are unconstitutional, it totals up to about 168 laws or parts of laws that were declared unconstitutional. And there are more state laws that have been declared unconstitutional. There weren't very many, but then in the early 1900s we see a big spike. And what happened here? Well, after the Civil War was the addition of the 14th Amendment that contains that Equal Protection Clause and the Due Process of Law Clause that have led to a lot of state laws being found to be being held unconstitutional. But if you add up all of the laws, all the state laws that the Supreme Court has declared unconstitutional since the 1800s, it totals up to around 1,300 or so. Now that's a lot more than the federal laws, but think about the arithmetic. We have 50 states, or however many states there were in each decade before that, and each year, each of those state legislatures passes some statutes, and so out of all of those years, and all of those tens of thousands, hundreds of thousands probably, of state laws that have been passed by state legislatures, only around 1,300 times have they been found unconstitutional. So what that tells us is that this an extraordinary power for an unelected court to exercise in a democracy, but it's not used very often. And so this infrequent use of judicial review, exercise of judicial review, suggests that there are some restraints on the court and its exercise of judicial review. So let's review what they are. And in this list, I'm going to do the reverse order. I'm going to talk about the most extreme and least useful and least effective constraints, and then end with the two that are the less extreme but probably most effective. So one democratic restraint on judicial review is that Supreme Court justices are subject to impeachment. Now, we've already learned that impeachment is an extreme act. It takes a supermajority in the Senate to convict and a majority vote in the House to impeach, and it's rarely been used as a check on the abuse of power. And so, how many Supreme Court justices do you suppose have been impeached? Well, the answer is one. That was Samuel Chase in 1804, but he was not removed from office. But there have been discussions, and the House has held hearings at other times considering bringing charges of impeachment against a Supreme Court justice. But only one time has the House impeached a Supreme Court justice, and that justice was not removed from office. However, political scientists who have studied this issue argue with some reason that just the threat of impeachment may be effective. The story of Chief Justice Marshall and his reluctance to rule the way he wanted to was in part the result of his view that he would probably be impeached. And there are other examples of Supreme Court justices that were acting in ways that were inappropriate or were irritating to Congress and the president. So the threat of impeachment, this club behind the door, can be an effective deterrent to the abuse of power. A second democratic restraint on the exercise of judicial review is a constitutional amendment. Now, when the Supreme Court exercises judicial review, it can do so in two ways. One way is a legislative interpretation, where they review a law passed by Congress and then make a ruling about what the intent of that law was. And if they interpret that law passed by Congress in a way that's contrary to what Congress intended, all Congress needs to do is just pass another law to clarify that no, the law is supposed to say this. But in some instances, when the court exercises judicial review, they're basing it on a constitutional interpretation. And so if the Supreme Court holds that a law violates some part of the Constitution and is therefore null and void, that's not something that can be overturned by just passing a law. But it can be overturned by passing a constitutional amendment. If the Supreme Court says this phrase, the equal protection of the law or due process of the law in the Constitution, means this, and if we don't agree with it, then Congress can propose and the state legislatures can ratify a new constitutional amendment that says that no, this is what the Constitution means. Now, we've already learned that it's very difficult to pass constitutional amendments, but in the book we go through and we point out a number of amendments that were added, that have been added to the Constitution over the centuries, that overturned unpopular rulings, exercise of judicial review by the Supreme Court. So this is also a rare and extreme measure, but it's one that has happened a number of times. A third restraint on the exercise of judicial review is turnover and appointments. Now, federal judges and Supreme Court justices in particular serve for terms of good behavior, a life term. But these are nonetheless human beings, and so their lives do end. They retire from office, or sometimes they die in office. And so if we just go through historically and look at how often a vacancy occurs on the Supreme Court through retirement or death, what we find is that on average, there has been a new justice appointed on an average of every 22 months, or about one every 2 years. Now that's an average, and so that averages out a lot of differences. So, for example, Jimmy Carter is the only president in history to serve a full 4-year term and never get an opportunity to appoint a Supreme Court justice. Whereas President Trump is just finishing out one term, and he has already appointed 3 new Supreme Court justices. So, but there is periodic turnover, but the timing of that can't be controlled. But then also know that the number of justices on the Supreme Court is not fixed by the Constitution. Instead, it's determined by law. That Congress, by law, the Constitution says there shall be one Supreme Court and various inferior courts as Congress shall deem necessary. And so Congress is the one that decides how many justices there are on the Supreme Court. And historically, there have been as few as 5 and as many as 10. The last time there was 10, this is an interesting instance. This occurred in the 1860s when Andrew Johnson was president. When Andrew Johnson succeeded to the presidency after Abraham Lincoln's assassination, there was a vacancy on the Supreme Court. And remember, Andrew Johnson was impeached and avoided removal from office by one vote in the Senate, so he was not very popular. And so the Federalists in control of Congress, rather than allowing Johnson an opportunity to fill this vacancy, just decided to eliminate the seat. Now keep in mind, the seat was vacant. And so Congress can say, all right, we're going to eliminate the seat. They couldn't eliminate a seat if there was already a justice sitting in it. But if the seat is vacant, then Congress can eliminate it. And then similarly, Congress also has the power to pass a law that increases the number of justices on the Supreme Court. And this was the philosophy of the so-called court packing scheme during the New Deal, when Franklin Roosevelt, was frustrated with the Supreme Court declaring all of his New Deal legislation that were designed to deal with the Depression unconstitutional. And so in 1936, he came up with this proposal. He actually did propose to create some new Supreme Court justices. And as I recall, the way it was worded, that, well, these are old men and they're getting old and so they need some help. And so let's appoint one new Supreme Court justice for every justice over the age of 60. As I recall, had that law passed, it would have increased the size of the Supreme Court from 9 to 15. And with those new seats on the Supreme Court, then President Roosevelt could have packed the court with New Dealers, with justices that would support the New Deal. Now, this is a very controversial proposal, and even most Democrats in Congress thought that this was not appropriate and a threat to judicial independence. So the law never came close to passing. But while all this was going on, there was a vacancy did occur by natural attrition, and then a second justice who continued began to vote to uphold New Deal measures, and so the need for that went away. But the point is that if the Supreme Court were to begin to just routinely declare laws that it didn't like unconstitutional, then Congress has the authority to add new seats to the Supreme Court to overdo that. That also is an extreme measure, and so it's not something that's easily done or would gain wide support unless the Supreme Court was really beginning to abuse those powers. Next, Congress also has control over the Supreme Court's appellate jurisdiction. Now, if you'll recall from reading the book, we note that there are two kinds of courts and jurisdiction. There are courts of original jurisdiction, and so these are trial courts that where there's a trial and there's a judge and a jury, and they determine guilt or innocence and so forth. And then there is appellate jurisdiction. And so appeals courts then hear appeals from decisions made by courts with the original jurisdiction. And the job of the appellate courts is to review the process or review the rulings to make sure that all of the rulings in the trial court were made according to the law and the Constitution. The U.S. Supreme Court is unique in that it is a court that has both original jurisdiction and appellate jurisdiction. The Supreme Court's original jurisdiction is very narrowly defined, and it's defined in the Constitution. And basically, the Constitution says that if there is a case involving foreign ambassadors and consuls, or if there is a legal dispute where one state sues another state, then the Supreme Court can sit as a trial court, and those cases can go directly to the Supreme Court. Cases arising under the Supreme Court's original jurisdiction are a minute fraction of its cases. The overwhelming majority of cases that the Supreme Court hears, well over 95% of cases, are cases that come to the Supreme Court under its appellate jurisdiction. And according to the Constitution, Congress decides which cases, by law, the Supreme Court has jurisdiction to hear appeals on, and the conditions under which those cases can be appealed. And so what that means is that if the Supreme Court started to abuse and just routinely declare laws passed by Congress as unconstitutional, then Congress could change the law and prevent the Supreme Court from hearing certain appeals. And this is the kind of thing that rarely happens, although that there have been some times in history where there were a number of bills introduced in Congress to restrict or take away some of the Supreme Court's appellate jurisdiction. They rarely pass, but the point is that is a restraint that the democratically elected policymakers, Congress and the President, can change by law. Next, the Supreme Court has no power to initiate the political process. Now, I've already indicated that political scientists generally agree that the courts are political institutions that make public policy. That's controversial among judges and lawyers, but it's pretty clear to us that a court decision, a ruling, is a type of public policy. But if the courts make policy, unlike policymakers, they have no power to initiate the process. If a member of Congress or a member of a legislature thinks there needs to be a new policy, they can just draft a law and introduce it. If the president thinks there needs to be a new policy or a new program, he can draw up a proposal and then get somebody from his party to introduce it in Congress. He can start the process going. But the Supreme Court must wait for cases to be presented to it, to be appealed to it. And remember that under the U.S. system, courts won't make hypothetical decisions, right? It has to be a real case involving real people who have suffered some real injury, and it must be the kind of case, an injury, which the court has jurisdiction to decide and has the power to decide. So the Supreme Court has to wait for these cases to come up through the judicial system, from the district court, from the trial court to the appellate court of appeals, and then appeal up to the Supreme Court. That can take years to happen. Now, it is the case that sometimes in a written opinion in the Supreme Court, the author of the opinion can write some things in there that signals a willingness to hear issues in the future. But even if that signal is clear and is heard, it's still likely to take several years before an issue can work its way up through the judicial process, from the trial court to the appellate court up to the Supreme Court. So the lack of ability to initiate the policymaking process is a real limitation on the Supreme Court's power or exercise of judicial review. Now, finally, these last two are the most important restraints on judicial review. And the next one is when the Supreme Court makes a decision, they must rely on other public officials to enforce that decision. When the Supreme Court held unanimously in Brown versus Board of Education that racially segregated schools violated the Equal Protection Clause of the 14th Amendment of the Constitution, what do you suppose happened in the fall of 1955 and 1956, where all of a sudden all of those racially segregated schools gone, No, because in order for that decision to be enforced, state legislatures, governors had to change the law requiring segregated schools. Then local school boards had to adopt policies and assignment to schools and so forth to enforce that decision. And in the case of Brown versus Board of Education, in many parts of the South, there was widespread resistance to it. A number of southern states, southern legislators, put their names on a petition resisting, saying that they were not going to enforce this. And it took decades of other court cases to get that to happen. But most of the time, there is a great deal of voluntary compliance with the Supreme Court's ruling. That all federal and state government officials, every member of the House and Senate, every federal judge, every member of the state legislature, every state judge and governor and state official, when they're elected or are appointed to official government office at the federal or state level, the Constitution says that they, quote, shall be bound by oath to support the Constitution. And so all of these elected officials take an oath to support the Constitution. And most of the time, there is a great deal of voluntary compliance, because even in those cases where these lower level policymakers disagree with the decision, they're likely to take the position, well, I don't like this. I think this decision is wrong, but I'm bound by oath to support the Constitution. And I don't like the Supreme Court. I don't like what they said, but they're the government body that has the authority, the legitimate authority to interpret the Constitution. So I'm bound by the Constitution and by oath to support this decision. And so that occurs in large part because of this myth of judicial objectivity that I talked about. As I said, we political scientists think it's a myth, but it's a very useful myth, and a myth that the courts and judges and law schools take great pains to perpetuate, because that gives the court the legitimacy that it needs in order to make independent decisions when the popularly elected branches of government or the majority take actions that's going to undermine something in the Constitution. And so this myth of judicial objectivity is a useful myth that helps the court maintain its legitimacy to hand down controversial decisions. Now, as a footnote, I might note that Marbury versus Madison is unique, or I don't know of any other cases, but it was unique in the sense that the exercise of judicial review in Marbury versus Madison was a self-executing or self-enforcing order. Why is that? Because it required no action from Thomas Jefferson. But all of these other cases of judicial review, the Brown versus Board of Education, lots of federal and state officials had to take action to dismantle segregated schools. The criminal procedure cases, the Miranda versus Arizona, that has the Miranda rights. You have the right to remain silent, the right to be represented by counsel, and so forth. When the Supreme Court handed down that decision, it was very controversial, and there were lots and lots of police forces all over the nation that didn't like it, but many of them complied with it because the Supreme Court had the legitimate authority to do that. But again, if the Supreme Court begin to abuse this power in the sense that they would just routinely substitute their own policy preferences for the preferences and decisions made by popularly elected officials, that will undermine their legitimacy. If the Supreme Court justices just started ignoring the Constitution, ignoring precedents, ignoring the law, and just substituted their own views of the way things should be, that will undermine their legitimacy. And if the court loses legitimacy, pretty soon all of those other officials that took an oath to support the Constitution will take the position that, well, the Supreme Court is not supporting the Constitution, and so therefore the president and members of Congress and governors and state legislatures and every other government official will say this court's no longer legitimate, and so we're not going to comply with it. So again, that hasn't happened yet. And if you'll recall earlier on, I noted that when Chief Justice Roberts was first appointed to the court, he was solidly in that conservative, that block of conservative justices that consistently voted conservatively. But as Chief Justice, the Chief Justice has a special duty to help maintain the integrity and maintain the independence and maintain the legitimacy of the Supreme Court. And so I noted that Chief Justice Roberts in recent years seems to be more likely to side with the liberals on the court in a number of cases, and that may be, and again I emphasize may be, an effort on his part to help maintain the legitimacy. Because if the Supreme Court just routinely substitutes its own view for the views of President Trump or whoever else they might be supporting, that will undermine their legitimacy. And the Chief Justice of all the justice has a special duty to help protect that legitimacy. And then finally, the Supreme Court justices exercise self-restraint. And notice that there's no law or constitutional requirement that they be lawyers, but they all have been lawyers, and most of them have graduated from the top-ranked, most elite law schools, and the legal training in every law school, from Harvard and Yale down to whatever, emphasizes that judges are supposed to be impartial. Judges are supposed to be neutral parties. And make sure that both sides are treated fairly, and so the lawyers that graduate from these law schools, they have been taught, and most of them surely believe that they're supposed to be objective, they're supposed to be impartial, that they're not supposed to just substitute their own preferences for the law, and we know from other research that even though many justices, probably most justices, may try to set aside their own personal ideology, their own personal partisan or political beliefs about something, we know that Democrats and liberals are likely to be swayed or influenced by certain kinds of arguments or certain kinds of evidence, whereas Republicans and conservatives may be swayed or are more persuaded by different kinds of arguments and different kinds of evidence. And so even though judges on both sides of the political spectrum may attempt to set aside their own political values, when they're evaluating the evidence, there's going to be room for reasonable people to disagree. And then also there are a number of judicial norms and legal doctrines that encourage and require restraint. The legal doctrine of stare decisis, that means stare decisis is a Latin phrase, it means let the decision stand. And so this is the doctrine that says unless there's a really good reason, a case that comes up today that is very similar in facts and so forth to a previously decided case the court should try to follow that precedent, follow the precedent because the law needs to be stable. And then to get into court, you can't just go in and make an appointment like you're going to make an appointment with your member of Congress and ask them to vote some way or to introduce some bill. You can't just go into a court and say, hey, we want you to take this case. There are legal rules. One of those rules is that the party, the plaintiff, must have standing, which means that they must have suffered a real injury, and they must have be in a position or a job or have the status that they are the appropriate ones to be making the claim. And then the Supreme Court also has these doctrines of ripeness and mootness. Ripeness just means that is this decision ripe for the Supreme Court to decide it? And what that means is, has it exhausted all of the other possible remedies? And if a case gets up to the Supreme Court, but it hasn't touched all of the bases, if it hasn't tried in every instance to get the dispute resolved, then the Supreme Court will say, would dismiss the case and say you have to go back and try to get it resolved in another court. And then mootness means that sometimes when a lawsuit is filed and there's great controversy, but then one way or another the issue gets resolved, and then when it gets up to the Supreme Court, there's no longer a controversy, and so the issue is moot, and the Supreme Court's not going to hand down a ruling in a case that's already been resolved. And so these are just a few examples of legal doctrines that the Supreme Court follows, and these are inherently conservative doctrines in the sense that they make it difficult for the Supreme Court, or they make it less likely for the Supreme Court to be able to intervene and substitute their own views. And so this one, self-restraint, combined with the lack of enforcement power, are probably the most effective restraints on the exercise of judicial review. So this is an extraordinary power. It's contrary to majority rule and popular sovereignty in a democracy, but as we can see, that there are a number of political, democratic restraints on the exercise of judicial review. Now, they're not electoral restraints. We can't vote them out of office if we don't like them, but there are nonetheless these democratic restraints. So this concludes our discussion of Module 13, and I think I got the module number wrong here, but there is I've canceled the last module on the bureaucracies, and that's chapter 14, and so what that means is that there will be no lectures and also no questions on the final exam from that.